My name is Michael Young, and I'm a lawyer who handles contested estates in Texas. In a fair number of the contested estates I handle, there will be an issue regarding a claim of common law marriage. Texas is one of the states that still recognizes common law marriages, and in short, those are marriages that are not established formally through a civil process of obtaining a marriage license and then having a marriage ceremony. But there's some confusion. People will call me and say, Mr. Young, we weren't married, but we were common law married. Well, it's the same thing. Once the marriage is established, a common law spouse has all the rights and obligations of a spouse that was married through a formal civil process. But in this video, I want to talk about what type of evidence I look at to establish the most important factor of a common law marriage. The three factors to establish a common law marriage in Texas is that the parties agreed to be married, the parties lived together as husband and wife, and that they held themselves out in the community as husband and wife. The first two are not difficult to establish typically. For the most part that I see, the dispute, the facts in dispute come down to whether or not both persons represented themselves in the community that they were married. And Texas cases say it has to be something more than just every once in a while, and it can't be just one way. You have to show that both spouses represented themselves generally in the community. So what type of evidence do I look for? Well, first thing is when I'm on either side of the case, either opposing the existence of a marriage or representing someone who's trying to establish it, first thing I want to do is talk to various witnesses, family members, friends, business associates, people at church, and try to get affidavits from them establishing whether or not they held themselves out to their knowledge to be married, or whether they were just living together, or whether, quote unquote, she was taking care of him, or something else that would not necessarily be a marriage. Second important thing is tax returns. Did they file as single or did they file as married? Deeds are important. If one of the persons has sold property while they were claiming to be married, or while that person was claiming to be married, and if they sold the property but they sold it as an unmarried person in the deed or in the transfer documents, well, that is going to be powerful evidence to contradict a claim of common law marriage, and I've had that in several cases. So once again, it's witness statements under oath, and then the documents. And the documents, while they could be tax filings, deeds, it could also be just something as simple as at the hospital or the doctor's office, listing as contact. Do they list the other person as a contact, and how are they described? Are they described as a friend, a companion, or are they described as a husband or a wife? There are many ways to establish that factor, but that's the type of evidence that I look for.